All right, welcome to this high-yield explainer. We've designed this specifically to give you the ultimate exam blueprint for Module 4 of your environmental law syllabus. If you're looking to secure top marks, well, you're in exactly the right place. We're going to strictly focus on the advanced regulatory frameworks you need to master, specifically the National Green Tribunal, the Forest Conservation Act, and exactly how international environmental principles are actively enforced right here at home. So grab your notes, get settled, and let's jump right into it.
To really grasp this module, we first got to ask ourselves a pretty fundamental question. Why do we even need a specialized court just for the environment? Well, before we look at the specific statutes, we really have to understand that traditional civil courts simply lack the scientific chops and, honestly, the sheer speed required to handle complex ecological disasters. I mean, when an ecosystem is actively being destroyed, you literally cannot wait years for a standard civil trial to play out. This massive gap created the absolute necessity for specialized tribunals, which ultimately led to the birth of the NGT.
So here's our roadmap for today. Number 1, the roadmap itself. 2, framework and global principles. 3, NGT procedural mechanics. 4, landmark environmental judgments. And 5, an exam synthesis scenario to tie it all together.
Let's dive right into Section 1, Framework and Global Principles. Okay, so we've got to trace the macro theory of how sweeping international treaties were actually absorbed into strict Indian domestic law. Examiners absolutely love to see this chronological evolution in your answers. The global seeds for environmental protection were first planted at the 1972 Stockholm Declaration and later the 1992 Rio Declaration. Now, these international treaties established the vital concepts of sustainable development and state responsibility. But look, a treaty means nothing without domestic teeth, right? Those global seeds eventually necessitated the domestic enactment of the Forest Conservation Act in 1980 and ultimately the immensely powerful National Green Tribunal Act in 2010. Now let's break down the three massive international doctrines you absolutely must cite. First up is the Precautionary Principle. The mandate here is to anticipate, prevent, and actively attack the causes of environmental degradation. So the crucial takeaway is this. If an action might cause irreversible harm, the absence of full scientific certainty cannot be used as a convenient excuse to postpone preventive measures. And even more importantly for your exam, remember that this principle shifts the burden of proof entirely onto the developer to prove that their project won't cause harm. Next is the Polluter Pays principle. This is a crucial, unavoidable doctrine for your exam. It asserts the absolute requirement that the polluting entity must bear the total financial cost of managing the pollution they created, plus restoring the damaged ecosystem. You need to explicitly state in your answers that the government, and by extension the taxpayers, are not responsible for financing environmental remediation caused by private industries. Basically, the polluter pays for the cleanup, period. The third pillar is the Public Trust Doctrine. This is the legal principle that the state acts merely as a trustee of our natural resources, stuff like our air, our water, and our forests. These are strictly preserved for common public use. When you write about this one, make sure to cite that these vital natural resources cannot be privatized or converted for purely commercial gain by the government. The state just holds them in trust for us and obviously for future generations.
All right, moving right along to Section 2, NGT Procedural Mechanics.
So, moving from macro theory to the actual micro-mechanics. Looking at past exam papers reveals that examiners frequently test the concept of no-fault liability applied by the NHT. This means strict liability is enforced entirely regardless of negligence. If a hazardous enterprise causes harm, they're liable to pay compensation, even if they took all reasonable precautions. There is absolutely no "we were careful" defense allowed here.
Unlike a normal trial that can drag on for decades, the NGT is specifically designed to act with blistering speed, simply because environmental damage doesn't wait for bureaucracy. While traditional civil courts rely heavily on formal, rigid evidentiary procedures bound by the Code of Civil Procedure and the Indian Evidence Act, the NGT isn't shackled by those strict rules. Instead, it directly integrates expert scientific data interpretation into its judicial process. It operates on the principles of natural justice, which allows it to move incredibly fast to issue injunctions and essential relief.
Okay, if you want top marks, you absolutely must cite these exact statutory sections of the NGT Act of 2010. Use this as your memory anchor.
Sections 14 through 25 cover the tribunal's jurisdiction, its powers, and its unique ability to grant relief, compensation, and restitution of the environment. Meanwhile, sections 26 through 28 contain the real heavy-hitting penal provisions. If a corporation decides to ignore an NGT order, these are the sections that allow for severe fines and even imprisonment.
Now, beyond the NGT, your exam will undoubtedly test the Forest Conservation Act of 1980. You've got to be ready to explain the strict domestic limitations placed on land use. Make sure you point out Section 2, which mandates that a state government cannot remove the reserved status of a forest without central government approval. Highlight that non-forest purposes, like clearing land for agriculture or construction, are strictly prohibited without explicit consent. And definitely cite Section 3, which establishes the central government's advisory committee to oversee these really crucial approvals.
Let's shift gears to Section 3, Landmark Environmental Judgments.
All right, we have the theory and the statutes. Now let's see how the Supreme Court and specialized tribunals actually apply these international doctrines in real landmark judgments. Because remember, cases are your evidence in a law exam. The Vellore Citizens Welfare Forum case from 1996 is the definitive judgment you must cite to demonstrate the domestic application of the precautionary principle. In this specific case, tanneries in Tamil Nadu were severely polluting the local water supply. The Supreme Court explicitly adopted the precautionary principle into Indian law, basically ruling that these industries had to proactively ensure their operations caused zero harm before they could continue. They couldn't just sit around and wait for the damage to be definitively proven.
Another massive, frequent exam target is the famous Span Motel case, which is formally known as MC Mehta v. Kamal. This is your absolute go-to citation for both the Public Trust Doctrine and the Polluter Pays principle. Basically, a motel tried to literally alter the course of the River Bias for private commercial benefit. The court firmly struck it down, declaring the river a public trust, and forced the motel to pay for the complete ecological restoration under the Polluter Pays principle.
Now, when you're discussing sustainable development, I really want you to memorize this exact phrasing from the Supreme Court in the Narmada Bachao Andolan case. Sustainable development means what type or extent of development can take place which can be sustained by nature or ecology with or without mitigation. Writing this exact quote down perfectly bridges the gap in your exam essay between necessary economic progress and the absolutely vital need for intergenerational equity.
And finally, Section 4. Exam Synthesis Scenario. Okay, we've reached the climax of this explainer. Let's take everything we've covered today and actually apply it. This is exactly where you prove you can think like an environmental lawyer. So here's your scenario. A massive corporate factory illegally clears a portion of a protected forest to expand their plant. And to make matters worse, they dump toxic, hazardous waste directly into the adjacent river, completely devastating the local ecosystem and the health of the downstream village. Now, when faced with a massive multi-layered violation scenario like this on exam day, don't panic. You have the tools. We're just going to apply the highly structured IRAC method: issue, rule, application, and conclusion.
Just follow this exact step-by-step legal argumentation framework to absolutely maximize your points. Step 1. State the issue. You'll identify the violations under Section 2 of the Forest Act for the illegal clearing and the water pollution that immediately triggers the NGT's jurisdiction. Step 2. State the rule. Here you'll cite the Rio Declaration, seamlessly pulling in the Polluter Pays and Public Trust Doctrines. Step 3. Application. You'll explain exactly how the NGT will use scientific data to apply absolute, no-fault liability straight against the corporation. And Step 4. Conclusion. Recommend that under NGT Act Sections 14 through 25, the corporation must pay total restitution, and under Sections 26 through 28, they face severe penal provisions for the hazardous dumping.
So there you have it. You are now fully armed with the exact statutes, the landmark cases, and the global doctrines required to conquer this module. I'm going to leave you with this final provocative thought as you prepare. Mastering environmental law isn't just about memorizing a list of strict rules. It's really about synthesizing those overarching global ideals from Stockholm and Rio with strict, uncompromising domestic enforcement. So how will you seamlessly weave those global ideals into your final exam arguments? Think on that. Good luck studying, and I will see you in the next explainer.